difference between the magistrate court trial and the crown court trial is that in the magistrate court, the magistrates are both the tribunal of law and the tribunal of fact. In the crown court, the tribunal of fact is jury. So there is no jury trial in the magistrate court. Trial in the magistrate court is called summary trial. It follows pretty much the same format as a trial in the crown court. The prosecution opens its case and calls its witnesses. So the prosecution is the one who opens the case and tells the brief story about the case to the judges and not to the jury. They are examined as discussed above. Then they call witnesses, and then witnesses are examined in chief, cross-examined and re-examined. Any agreed statement can be read. So if both parties agreed to a statement, so then there is no need to call a witness. That kind of a statement given by that person or witness can be read into the court. At the conclusion of the prosecution case, the defense can make a submission of no case to answer. So as in the crown court, the magistrate court, the defense can also make submission of no case to answer, that there is no sufficient evidence against that person, so that person must be acquitted at once, and the decision of the case should be given at once in the favor of the defense. So if magistrates do not agree to the submission of no case, then the defense is to be called and to give their evidence, and after that the defense witness come, and then those are witnesses are examined in chief, cross-examined and re-examined. At the conclusion of the defense closing speech, the magistrate retired to consider their verdict. So after all of the course of the procedure of the trial, the magistrate themselves retire and decide the verdict themselves without using any jury. The main difference between the magistrate court and crown court stems from the fact that magistrate are tribunal of both fact and law. So magistrate court is the tribunal of both fact and the law, and there is no jury, there is no need to jury. So none has to be selected or so on. So no jury has to be selected. Any argument as to admissibility of evidence must be addressed to the magistrate. So the case of admissibility of the evidence should come to the magistrate, and the party that does not agree to the evidence because of the question of admissibility must ask the magistrate to struck down that kind of evidence. If they conclude that evidence is inadmissible, they must ignore it. So if magistrates agreed that such an evidence is inadmissible in the court of law, they will not make a decision of the case based upon that evidence and shall ignore that kind of evidence. So if for example they decide defendant wasn't told of his right to a legal advice and that confession was inadmissible, they would have the difficult task of ignoring that kind of evidence at the time of reaching the verdict.